after a careful review of the constitutional provisions, outstanding orders, the case law, and the rules and practice of other parliaments around the world on a matter of absenteeism of a member of parliament from sittings of parliament, I noted that a member or any person would be stopped from raising an issue of absenteeism after the meeting, and thus a member of parliament or any person that desirous of doing the same must act timeously during the course of the meeting that the member is alleged to have absented himself from the sittings. I also noted that the combined effect of our Constitution, standing orders, and case law provides a certain process to be followed when it comes to a notice of the House that a member had absented himself or herself from the sittings of Parliament in a manner that is inconsistent with the letter and spirit of Article 97(1)(c) of the 1992 Constitution. For the avoidance of doubt, I reiterate what I highlighted in that statement, and I particularly will refer to paragraph 19 of the statement, and it reads as follows. 19. In the light of the combined reading of the provisions in the Constitution and the standing orders above, coupled with a decision of the Court of Appeal on the question of when a seat of a member of Parliament is vacant by reason of absenteeism, the following processes should be complied with. 1. The member must have been absent from a meeting for 15 sittings in that meeting without the permission of the Speaker in writing, based on the evidence from the votes and proceedings of Parliament. 2. The fact of the absence of the member without permission of the Speaker may be raised on the floor of Parliament by a member, and the matter referred to a committee of privileges for consideration and report to the House. 3. The members so referred shall be required to offer an explanation for the absence to the committee of privileges, which shall consider whether the explanation is reasonable. 4. The committee of privileges, after consideration, shall recommend to the House such action as the committee may consider appropriate. 5. The House shall vote on the recommendation of the committee, where in the event that the committee's recommendation to the House is to the effect that the member's explanation is reasonable, and the House adopts that recommendation, the member's seat shall not be declared vacant. Where in the event that the committee's recommendation to the House is to the effect that the member's explanation is unreasonable, and the House adopts that recommendation, the member's seat shall be declared vacant by Mr. Speaker. Where Mr. Speaker has declared a seat vacant by reason of absenteeism, the Clerk to Parliament shall, within 7 days of the declaration, notify the Electoral Commission for the necessary processes for a by-election to commence, unquote. Having regard to the process outlined above, the Committee of Privileges considered the matter of absenteeism involving the 3 members who had absented themselves from sittings of the House in a meeting without the permission in writing of the Speaker. I will give a fuller explanation of the role each of the actors plays in this matter, only if necessary, at the conclusion of this matter. Suffice for this purpose to restrict myself to the role of the Committee of Privileges. The committee has a singular mandate in respect of these matters, and that is to establish that the member absented him or herself from the sitting of Parliament for 15 days in a meeting without the permission of the Speaker in writing, require into the reasonableness, I should say inquire, not require, inquire into the reasonableness or otherwise of the explanation offered by the affected member or members, and to report to the House. Order 7 defines a standing committee, like the Committee of Privileges, as a committee appointed under Article 1031 of the Constitution to inquire into and report on such matters as may be referred to it from time to time or on a continuous basis for the declaration of Parliament. A Committee of Privileges is a committee of Parliament constituted pursuant to Article 103 of the Constitution. As a committee of Parliament, the way in which the committee conducts itself is regulated by the standing orders of the House. It is provided by Article 1101 of the Constitution 1992 that, and I quote, subject to the provisions of the Constitution, Parliament may, by standing orders, regulate its own proceedings, unquote. Article 97 1C stipulates the conditions under which the seat of a member of Parliament may be vacant. Put differently, once the member has A, been absent from Parliament for 15 sittings of a meeting of Parliament, B, not obtained the permission of Mr. Speaker in writing to be absent, and C, cannot offer a reasonable explanation to the Parliamentary Committee on Privileges, the member automatically vacates the seat. This is the position that was endorsed in the case of Professor Stephen Kweku Asare versus the Attorney General and 3 others, unreported 2008 Court of Appeal. And I want to quote what they said. The plaintiff appellant, here after referred to as the appellant, contends that once a member absents himself from Parliament without explanation for more than 15 sittings in this case, that member's seat automatically becomes vacant by operation of law. This argument is sound in law and I accept it, unquote. On the other hand, Order 161 of the Standing Orders provides, 1, the recommendations of a report of committee shall be presented to the House in the form of a report. 2, at any time after the report has been presented to the House, a motion may be moved by the chairman of the committee for the acceptance of the report. Our orders specifically require that the recommendations of a committee must be subject to the consideration of the House, and that the plenary plays an important role in choosing to adopt or reject the recommendations. The rationale for this structure is that committees of Parliament are macrocosms and extensions of the House as a whole. They are handmaidens whose core constitutional function is to assist Parliament, in the language of Article 1031 of the Constitution, in, I quote, the effective discharge of its functions, unquote. There are, however, a few exceptions to this general rule. As noted by the Majority Leader, Articles 106(13), and that's clause 13, and 177 provide instances where the Committee of Parliament's work operates to automatically bind the House, and no consideration whatsoever is required by the plenary in these matters. May I add that it is also the case with the recommendations of the Committee of Members holding office of profit. In such instances, the Constitution specifically says so. Very clearly stated in the Constitution. Most parliamentary decisions are made by the House acting on the recommendations of one of its committees. It does not follow that all decisions in Parliament must be done that way. Where the Constitution itself specifies a particular process for deciding, then it is that process that must be followed. This is because general things do not derogate from special things. However, in contrast with these instances cited, there's nothing, and I mean nothing, expressly stated or necessarily implied in Article 97(1)(c) to the effect that the conclusion of the work of the Committee of Privileges also concludes the matter, and no action may be taken by the House on the findings and recommendations of the committee. Furthermore, the instances cited are not referrals from the House to the Committee of the House. Article 177, for instance, indicates that the advances from the contingency fund may be authorized by the Committee for Finance once the committee is satisfied that there has arisen an urgent or unforeseen need for expenditure for which no other provision exists to meet the need. The plenary in this case is not seized with jurisdiction to make a reference or determination on the decision of the Committee for Finance. In fact, the Constitution says the committee in charge of financial matters. The distinction between this provision and Article 97(1)(c) is that in the case of the former, no reference is made by the House in any way to the Committee for Finance. The minister responsible for finance in making a request for an advance from the contingency fund is not required to come to the House, but can submit his request to the Committee for Finance. The House plays no role in the process. The Constitution mandates the Minister of Finance, after the authorization of the Committee of Finance, to as soon as possible present a supplementary estimate for the purpose of replacing the amount so advanced. That's what is stated in the Constitution. And that is very different from the position in Article 97(1)(c). On the contrary, in relation to the matter before us, the absenteeism of the 3 members is referred to the committee in accordance with Article 97(1)(c), after the allegation that the members were absent for 15 days without permission in writing by the Speaker. A committee of the House is then called upon to inquire into the allegations and report to the House for a decision. I find the position canvassed strongly by the Majority Leader as untenable, for the simple reason that where the framers of the Constitution intended that the committee be clothed with exclusive jurisdiction on a matter without reference to the House, it has expressly, as in the case of Article 106(13) and 177, indicated so within the text of the Constitution. To the extent that a similar express mandate is not conferred on the Privileges Committee in respect of matters arising under Article 97(1)(c), Parliament's procedure with respect to the committees must of necessity apply. To imply any mandate into Article 97(1)(c) is one I am not prepared to do. Pursuant to Article 110 of the Constitution, my understanding is that where the Constitution does not provide a procedure, Parliament may regulate the procedure within that space as long as it does not offend the Constitution. It is in accordance with this power that Parliament captured the dictates of Article 71(c) in Order 16(1), which is to the effect that once a member is alleged to be in breach of the provision, his conduct is referred to the Committee of Privileges for inquiry. For the purpose of reiterating my humble view, once a referral has been made, therefore, the report of the committee does not complete the inquiry into the matter. The report of the Committee of Privileges just like any other committee, is subject to the consideration of the House by way of a motion. Again, I am inspired and convinced this position of the law by the provision of the Constitution, rules of procedure and practice of the United Kingdom, India, Canada, New Zealand, and Australia. In conclusion, honorable members, as I have noted in this ruling, the decision as to whether or not to admit a motion is the exclusive preserve of the Speaker. In view of the foregoing, the House is well within its rights to receive and consider the report of the committee and make a determination arising out of the recommendations. In the circumstances, it is my ruling that the motion was rightfully admitted and the report of the committee is subject to the consideration of the House. It goes without saying that the preliminary objection of the majority leader to the admissibility of the motion for consideration of the report of the committee is hereby dismissed in limine. Honorable members, I did indicate that I will give my understanding at the end of the debate on this matter, and I'll give you copious referral notes on this issue. Because it's my humble view that even what the table office does in trying to compute the days that a member absents himself is not final. It's for the committee to investigate and establish the facts. Again, the fact that the Speaker or is alleged that the Speaker has not given permission in writing is also not final. Evidence must be produced before the committee. And the last thing is for the committee. The fact that the committee says, oh, this reason is reasonable, this reason is not reasonable, is not also final. It's for the House that will go through it, because the mandate given to an MP, representation, is so crucial that it cannot be left to the subjective view of any person or group of people, but the whole House. Please, honorable members, table office will accordingly list the motion, and this House will continue to deliberate and debate on it and take a final decision. I so rule.